This is Duke University.
Good afternoon. There's seats down in front, Professor Knight, Gulati. I'm David Levy, Dean of the Duke Law School. Welcome to the Brainerd Currie Memorial Lecture. This lecture series is named in honor of Professor Brainerd Currie, who taught contracts, admiralty, and conflicts of laws at Duke from 1946 to 1949, and then again from 1961 to 1965. He was an admired scholar and beloved teacher at Duke, as well as at several other law schools. He was perhaps the preeminent theorist on the conflict of laws, certainly during his time. This lecture series began in 1967, and it has brought scholars of the first rank to Duke Law School. This year is no exception. How fortunate we are to have Akhil Reed Amar as our Currie lecturer. Professor Amar is the Sterling Professor of Law and Political Science at Yale, where he teaches constitutional law both in the law school and in the college. He joined the Yale faculty in 1985. He's had a most distinguished career. He's won many awards for both his scholarship and for his teaching. He's a member of the American Academy of Arts and Sciences. His latest book is titled America's Unwritten Constitution, and thanks to Professor Amar's generosity, many of you have received a copy of that book gratis from Professor Amar today. It is an honor to have him here. Please welcome Professor Amar.
Thank you, Mr. Dean. Thank you so much for coming. It's really an honor and a privilege to be here. I've never been here before, and I traded up in weather. So and people would say in other respects as well. So thank you so much for coming. The title of this lecture is Lex Majoris Partis: How the Senate Can End the Filibuster on Any Day by Simple Majority Rule. Though I never knew Professor Brainerd Currie, he died when I was just a lad, I did know and admire his son, Professor David Currie, who passed away in 2007. I was especially impressed by the younger Currie's sustained interest in congressional constitutionalism. That is, various constitutional issues that have arisen in Congress and that have often involved special rules and procedure of Congress itself. In the tradition of the younger Professor Currie, I propose to use this hour as the 2013 Currie Lecture to address one of the most important contemporary issues of congressional constitutionalism, the Senate filibuster. In this hour, I shall argue that contrary to what many senators say and what some of them might even believe, the Senate may eliminate current filibuster practice on any day it chooses, and may do so by simple majority vote. My main argument today reprises material from my recent book, America's Unwritten Constitution, The Precedents and Principles We Live By, and I'm particularly grateful that the Duke Law School has arranged for copies of this book to be given to students in attendance today. Don't let the professor steal the copies. Keep an eye on them. In a brief coda to my main argument, I shall offer additional elaboration, placing my views in the context of recent events on Capitol Hill, and explaining how my proposed approach intersects with long-standing arguments about whether the Senate is or is not a continuing body. And I brought my Marco Rubio water with me. And at the Harvard Law School, the course on federal jurisdiction taught by the great Professor Henry Hart of Hart and Wexler fame, now co-edited by the good dean's cousin, Dan Meltzer, was affectionately known as Darkness at Noon. So I think that was just a reminder to us. And Professor David Currie did actually study under Professor Hart at Harvard Law School, so I think the universe is trying to tell us something, because it is noon and it was dark. Multi-member institutions, such as the House, the Senate, and the court, can do nothing at all, unless certain basic social choice rules are in place within these institutions. Crucially, there must exist master rules that determine how many votes within each institution will suffice to achieve certain results. Yet the written Constitution does not textually specify the master voting rule that operates inside these three chambers. Happily, 2 centuries of actual practice make clear that the bedrock constitutional principle within each is simple majority rule. Some senators, however, today think otherwise. They think that the Senate's current filibuster system cannot be abolished by simple majority vote. They should think again, for they've misread America's Constitution, written and unwritten. To see why, let's first canvass the internal voting rules and deliberation protocols that apply within the Supreme Court and the House of Representatives, and then let's use that evidence and the insights generated by this canvass to analyze the modern Senate filibuster. Excuse me. The Constitution explicitly provides for a Chief Justice, but does not specify his role except as the official who chairs presidential impeachment trials. Perhaps the Chief's most important court role, established by court tradition, involves the power to assign opinions. Whenever he finds himself in the initial majority after oral argument, he decides which justice shall take the lead in trying to compose the opinion on behalf of the court. Of course, he may opt to assign the opinion-writing power, duty, to himself, as John Marshall did in most important cases of his day, and as Earl Warren did in landmark cases such as Brown v. Board and Reynolds v. Sims. Thanks to the Necessary and Proper Clause, Congress has also vested the Chief Justice with sundry administrative and supervisory responsibilities for the federal judiciary as a whole, but none of these congressional statutes has done much to clarify the Chief's authority within the Supreme Court itself. And while Congress has defined the jurisdiction of the court and has enacted various rules of evidence and procedure for litigants who come before the justices, federal lawmakers have opted to leave a great deal of the internal protocol among the justices to be worked out by the justices themselves. But by what voting rule? While the written Constitution left the matter unspecified, 4 interrelated factors pointed to simple majority rule as the master norm among the justices, at least in the absence of some contrary protocol prescribed by Congress. First, majority rule has unique mathematical properties that make it the obvious answer. When an uneven number of justices, voters, are deciding between 2 simple alternatives, such as whether to affirm or reverse a lower court decision, or whether to rule for the plaintiff or the defendant in the trial situation, there's always an alternative that commands the support of a majority, but there might be no alternative that enjoys more than majority support. Second, anyone who had studied Locke's canonical Second Treatise of Government, as had most of the leading American revolutionaries, had learned that majority rule was the natural default principle of all assemblies. In Locke's words, quote, "In assemblies empowered to act by positive laws, where no number is set by that positive law which empowers them, the act of the majority passes for the act of the whole, and of course determines, as having by the law of nature and reason the power of the whole." Other founding-era authorities said the same thing. Building on this broad tradition, Thomas Jefferson's mid-1780s booklet, Notes on the State of Virginia, declared that, quote, "Lex Majoris Partis is founded in common law as well as common right. It is the natural law of every assembly of men whose numbers are not fixed by any other law," unquote. In written remarks read aloud to the Philadelphia Convention, Benjamin Franklin described majority rule as, quote, "the common practice of assemblies in all countries and ages," unquote. None of his fellow delegates said otherwise. So we've got now Locke, who wrote, of course, the Carolina Constitution way back in the 1680s, and Jefferson and Franklin. We're doing okay so far. Third, the Constitution's text evidently incorporated this majoritarian premise, albeit by implication. Whenever a federal institution was authorized by the Constitution to make certain decision using some principle other than simple majority rule, the exception to this implicit rule was specified in the document itself. For example, the text makes clear that a two-thirds vote is necessary for the Senate to convict an impeachment defendant, or approve a proposed treaty, or for either house to expel a member, approve a constitutional amendment, or override a presidential veto. For other actions, simple majority rule simply went without saying. Several of the Constitution's provisions prescribing supermajorities make the most sense only if we assume that majority rule was the self-evident background principle that applied in the absence of a specific clause to the contrary. Thus, Article 1 presupposed that each house would pass legislative bills by majority vote, except when trying to override presidential vetoes, which would require a special supermajority, 2/3. The supermajorities for constitutional amendments, 2/3, likewise were designed to be more demanding than the simple majorities for ordinary statutes. The Senate supermajority for treaty ratification was meant to erect a higher bar than for ordinary Senate agreement to ordinary legislation, a higher bar meant to offset the absence of the House in the formal treaty-making process. Similarly, the provisions empowering each House to exclude improperly elected or constitutionally ineligible candidates were meant to operate by simple majority rule, as distinct from the exceptional supermajority rule that applied when a House sought to expel duly elected and fully eligible members. But if majority rule truly went without saying, I hear you say, then why did the framers feel the need to specify in Article 1, Section 5 that a majority of each House would constitute a quorum? The obvious answer is that state constitutions and British practice had varied widely on the quorum question. And thus, on this special issue, there did not exist an obvious default rule from universal usage or mathematical logic. For example, Pennsylvania set the quorum bar at 2/3, whereas the English rule since the 1640s have provided that any 40 members of Parliament could constitute a quorum of the House of Commons. But neither Parliament nor any state circa 1787 generally required more than simple House majority votes for the passage of bills or the adoption of eternal House procedures, even though in many of these states no explicit clause explicitly specified this voting rule. In America circa 1787, majority rule in these contexts thus truly did go without saying. We should also note that the Constitution's electoral college clauses explicitly speak of the need for a majority vote. In this context involving candidate elections, majority rule did not go without saying as the obvious and only default rule. Plurality rule furnished a salient alternative, and indeed the rule that even today remains the dominant one for candidate contests in America. But this point about candidate elections, which might involve voting on 3 or more persons simultaneously, did not apply to the enactment of House rules or the exclusion of members under Article 1, Section 5, or the enactment of laws under Article 1, Section 7, all of which involved binary decisions against the status quo. As noted, majority rule has unique mathematical advantages in situations of binary choice. Fourth, and as explained in considerable detail in my book, America's Unwritten Constitution, majority rule was not only implicit in the Constitution's text, but also visible in its very enactment. Nothing in Article 7 explicitly said that the 13 state ratifying conventions should act by simple majority rule. But this is what every convention did, and in a manner that suggested that the issue was self-evident. Thus, in a wide range of constitutional contexts, majority rule went without saying. For the same reason, this background rule applied to ratifying conventions and to each House of Congress, for the same reason this background rule applied to ratifying conventions and to each House of Congress, it applied to the court as well. From its first day to the present day, the court has routinely followed the majority rule principle without even appearing to give the matter much thought. As a rule, when 5 justices today say the law means X and 4 say it means Y, X it is. Over the years, the court has invalidated dozens of congressional laws by the slimmest of margins, 5-4. Politicians and commentators have occasionally urged Congress to respond with a statute forbidding the court to strike down federal legislation unless the court vote is at least 6-3. Yet Congress has never followed this advice, and with good reason. For hidden within this proposal, there lurk at least 2 distinct and insuperable Article 6 supremacy clause problems. First, in situations not governed by the proposed statute, the court would presumably continue to operate by majority rule. For example, Congress surely would not want the court to enforce state laws violating congressional statutes so long as the state got 4 of the 9 court votes. But if simple majority vote would suffice to vindicate a federal statute over a state law, the same simple majority vote should suffice to vindicate the Constitution over a federal statute. By trying to change the court's voting rules selectively, the proposed statute would violate the legal hierarchy laid down in Article 6, which privileges the Constitution over federal statutes in exactly the same way it privileges constitutionally proper federal statutes over mere state laws. Second, and more generally, any statute that gave a jurist brandishing a mere congressional law or any other subconstitutional law a weightier vote than a dueling jurist wielding the Constitution would improperly invert the clear prioritization of legal norms established by the Supremacy Clause. Could the justices themselves, could the justices themselves decide by simple majority rule to abandon court majority rule in some situations where these sorts of Supremacy Clause problems do not arise? In fact, the court has done just that, but in a manner that's preserved the ultimate authority of majority rule. By court tradition, 4 justices, a minority, can put a case on the docket and can ordinarily guarantee that the petitioner seeking review will be able to press her case via full briefing and oral argument. But ultimately, the court majority of 5 has the last word, not just on the merits of the case, but on whether the court itself will in fact issue any opinion. At any time, a simple court majority of 5 can dismiss any case on the docket, dig it, dismiss it as improvidently granted, even if the remaining 4 justices adamantly object. In short, minority rules, such as the rule of 4, nest within a framework of simple majority rule. Isn't this dramatic? See, this was so that the cameras could go off and I could go off stage and, while we're maintaining eye contact and have another sip of water. A similar analysis applies to voting rules followed by the House of Representatives. In general, the House follows the Constitution's implicit directive of simple majority rule in performing its basic constitutional functions, enacting legislation, authorizing expenditures, they used to do that back in the day, organizing itself, judging its members' elections and qualifications, issuing subpoenas, adjudicating contempts, maintaining order within its own walls, and impeaching executive and judicial officers. All by majority vote of the House. True, a labyrinth of House rules, most obviously a set of rules enabling committees and House leadership to dictate the House agenda, and another set of rules regulating parliamentary procedure, may prevent a given matter from ever reaching the House floor for a simple majority vote. But these internal rules are themselves authorized at the biennial beginning of each new Congress under the aegis of Article 1, Section 5, and they're authorized by a simple chamber majority in keeping with the Constitution's letter and spirit. Not so with what has now become perhaps the most dysfunctional aspect of modern American institutional practice. This is a tough competition. The most dysfunctional aspect of modern American institutional practice, the Senate filibuster. Thanks to an internal Senate rule allowing filibusters, Senate Rule 22 to be precise, the de facto threshold for enacting a wide range of legislation has in recent years become 60 votes instead of the constitutionally proper 51 votes. Under Rule 22, a mere 41 senators can prevent a typical bill from ever reaching the Senate floor for a final vote, even if 59 senators on the other side are intensely eager to end debate and improve the bill. Can you spell gridlock? Yes, you can spell gridlock. The filibuster rule itself is not approved biennially at the outset of each new congressional term. Rather, this old rule, initially adopted by the Senate in the 19-teens and significantly revised in the 1970s, simply carries over from one Congress to the next by inertia under the notion that the Senate, unlike the House, is a continuing body. Thus, Senate rules, once in place, need never be formally reenacted. Similarly, Senate leaders, once in place, need never be formally re-elected. But the Senate does generally retain the right to oust any holdover leaders at any time, and to do so by simple majority vote. And this majoritarian principle, which clearly applies to holdover Senate leaders, should also apply to holdover Senate rules. Thus, all Senate rules, including the filibuster rule, are valid if and only if A majority of the Senate at any time may change the old rules by simple majority vote. Some senators today seem to believe that a simple Senate majority cannot change the old filibuster rule, even if the Senate majority emphatically wants change. Why not? Because the old filibuster rule says so. That's some catch, that catch-22. This circular logic will not do. The filibuster rule, like every other American law or regulation, is ultimately subordinate to America's Constitution. If the Constitution requires ultimate majority rule in the Senate, no purported Senate rule may properly say otherwise. And in fact, America's Constitution, correctly understood, does require ultimate majority rule in the Senate, insofar as the old filibuster rule claims the status of an entrenched protocol that cannot be altered by an insistent current Senate majority, then the old filibuster rule is to this exact extent unconstitutional and should be treated as such by the Senate itself, acting as the proper promulgators and judges of their own procedures. Concretely, if a simple majority of the Senate ever did take steps to repeal the filibuster rule, the Senate's presiding officer should rule this repeal to be in order, and this ruling from the chair should be upheld by a simple Senate majority. There would be a point of order objection, and it should be upheld by a simple majority, Senate majority, and that would be that. No more Senate filibusters. We need not insist that a current Senate majority has the right to change its rules instantaneously and peremptorily. Thus, the Senate's presiding officer may properly allow each side ample time to make its case before holding a vote on a Senate rule change. But any attempt to prevent a reform vote altogether via dilatory tactics, that is, any attempt to indefinitely filibuster attempted filibuster reform, would violate the applicable written and unwritten constitutional principles. This conclusion may astonish. Some might think that if the name of the game is close attention to actual government practice, the fact that the Senate filibuster exists and the fact that that many senators claim that it cannot be altered by a simple Senate majority are unanswerable game winners, if the name of the game is actual institutional practice. It's precisely at this point that the framework that I put forth in my recent book, America's Unwritten Constitution, proves its worth. In a nutshell, I argued that in the book that there exist various tools and techniques enabling interpreters to range beyond individual words and clauses in the written Constitution while remaining entirely faithful to the grand project of American constitutionalism. Let us then carefully apply this framework to the filibuster issue. And if you have the book right now, you could actually flip it open, just sort of scan the table of contents, and you'll see that each chapter sort of identifies a different tool or technique. And I'm actually going to kind of walk down that table of contents with you and try to apply this method to the filibuster. If you find the table of contents, begin by noting that even though majority rule is not always explicitly specified in various clauses of the written Constitution, it surely forms part of America's implicit Constitution in certain respects. That's Chapter 1, reading between the lines, the implicit Constitution. If the Senate may entrench, that is, enact and insulate from simple majoritarian repeal a rule that 60 votes are required to pass a given bill, sometimes they're bull, the Senate could likewise entrench a rule that 70 votes are required, or 80 or 90 for that matter. But such a rule would plainly violate the letter and logic of Article 1, Section 7, which provides that a two-thirds Senate majority always suffices, even when the president vetoes a particular bill. Surely it follows a fortiori that something less than two-thirds suffices in the absence of a veto. And that something is majority rule, as is powerfully evident from America's enacted Constitution. That's Chapter 2. That is, from the very process by which the written text itself was enacted into law and thus sprang to life. This enactment process in 1787-88 confirms that majority rule does indeed go without saying in the Constitution, in the absence of strong implicit or explicit contraindication. Here's the key fact. Majority rule supplied the self-evident master norm for state ratifying conventions organized under Article 7. For example, the vote in New York was 30 to 27, and the 27 didn't squeak. This key fact provides a compelling reason to believe that majority rule likewise provides the self-evident master norm for senatorial legislation under Article 1, Section 7, and for senatorial internal rulemaking under Article 1, Section 5. Thus, unless we find in the written or unwritten Constitution some strong contraindication, majority rule is the Constitution's proper voting protocol when the Senate decides whether to keep or scrap the filibuster rule. Nothing in America's lived Constitution, that's the third chapter, the norms and customs of ordinary Americans living out their daily lives, provides a strong contraindication. While it would be surprising if the daily rhythms and routines of average Americans decisively answered technical questions concerning the Senate's internal procedures, it's perhaps notable that when average Americans participate in various clubs and the like, they quite often and without much ado practice majority rule. That chapter is really just about how ordinary people live their lives and how that generates unenumerated rights. Nothing in the written Constitution gives you a right to play the fiddle, to have a pet dog, to relax on your porch, to enjoy conjugal happiness. But this is America. Ordinary people live their lives that way. So that's the lived Constitution idea, sort of very Burkean. Likewise, nothing in America's doctrinal Constitution, that's chapters 4 and 5, based on judicial teachings, supports the entrenched filibuster. Not only have the justices themselves always followed majority rule, as we saw, but in the 1892 case United States versus Ballin, the court explicitly embraced majority rule as the background master norm for each House of Congress. Quote, "The general rule of all parliamentary bodies is that when a quorum is present, the act of a majority of the quorum is the act of the body. This has been the rule for all time, except so far as in any given case, the terms of the organic act under which the body is assembled have prescribed specific limitations. No such limitation is found in the federal Constitution, and therefore the general law of such bodies obtains." And note, by the way, how much that tracks what Locke said and what Jefferson said and what Franklin said, and not coincidentally. Nor does anything in America's symbolic Constitution, that's another chapter, the special cultural icons in our legal cultural pantheon, such as Lincoln's Gettysburg Address or Dr. King's I Have a Dream speech, argue for the entrenched Senate filibuster rule. Many ordinary citizens today disdain Senate Rule 22, and this disdain has a long history. The most memorable filibusters in the American experience occurred in the 1950s and early 60s, when various Southern senators tried to thwart much-needed civil rights legislation that eventually passed in the mid-1960s and became the pride of the nation. We need to tell the Supreme Court that next week, by the way. Reaffirming the equality of all races and also both sexes. In short, key elements of America's symbolic Constitution came about despite the filibuster, not because of it. Nor, finally, does the history of actual institutional practice, that's chapter 9, America's institutional Constitution, the actual practice provides solid support for an entrenched filibuster rule. Properly construed and contextualized, the history of actual Senate practice, in fact, supports modern-day filibuster reformers. Nothing like Rule 22's Catch-22 was in place in the age of George Washington or in the Jeffersonian era that followed. Throughout the 1790s and early 1800s, the Senate practiced and preached simple majority rule. Under the procedures that governed the Senate during its earliest years, a senator could move the previous question and thereby end debate if a majority of senators agreed, And senators could also call an unruly orator to order at any time and thereby oblige him to, quote, sit down, unquote, subject to a ruling by the chair and, if necessary, an appeal to the Senate as a whole. While some scholars have quibbled about the precise operation of these initial rules, the history of the Senate prior to the 1830s offers no notable examples of organized and obstructionist filibustering, and absolutely nothing like a pattern of systematic, self-perpetuating, entrenched frustration of Senate majority rule. See, if there were such a thing, you'd know it. You would have learned it in American history. There is no such thing. I can't prove the negative, but no one's come up with anything. Thomas Jefferson, the Senate's presiding officer, remember he's vice president, from 1797 to 1800, was thus describing actual senatorial norms and usages when he penned the following passage of his 1801 Manual of Parliamentary Practice for the Use of the Senate of the United States. Quote, "No one is to speak impertinently or beside the question, superfluously or tediously. The voice of the majority decides." I know, isn't that amazing? That's how the Senate was actually supposed to work. No one's supposed to speak impertinently or beside the question, superfluously or tediously. The voice of the majority decides. For the Lex Majoris Partis is the law of all councils, elections, etc., were not otherwise expressly provided. Unquote. For much of the mid-19th century, even as Senate minorities began to develop and deploy dilatory tactics, these tactics typically occurred with the indulgence of the Senate majority. Long-winded speechifying occasionally delayed the Senate's business, but ordinarily, orations did not prevent majorities from ending debate at some point and taking a vote. The Senate in those days was smaller and had less business to transact. The upper chamber often opted to indulge individual senators as a matter of courtesy. Yeah, there used to be such a thing as courtesy back in the day. In turn, the indulged senators did not routinely try to press their privileges so as to prevent Senate majorities from governing. For example, in 1850, politicians of all stripes from all regions understood that California's admission, giving free states a narrow but decisive majority over slave states in the Senate, mattered hugely, precisely because the Senate's operative principle in the mid-19th century was, in fact, simple majority rule. That's why the Compromise of 1850 and California's admission was, in Joe Biden's phrase, a BFD. According to one expert treatise, prior to the, I don't know if Chris Schrader is here, but he would appreciate, yeah, okay, there, okay. According to one expert treatise, prior to the 1880s, virtually every obstructed measure eventually prevailed against the opposition's stalling tactics. And by the way, you see, Biden is the presiding officer of the Senate. This is a paper designed to persuade him, so make sure he gets it, Chris. Okay, thank you. In the late 20th and early 21st centuries, routine filibustering practices have skyrocketed. Yet senators in the modern era have failed to achieve a general consensus via a compelling line of clean, consistent Senate rulings on the key constitutional question. Properly framed, the question is not whether the Senate may choose by inaction and inertia to keep the filibuster, nor whether the Senate may choose to keep the filibuster by readopting it via a fresh majority vote. Rather, the question is whether the current Senate is simply stuck with the old filibuster rule, even if a current majority emphatically wants to change the rule and explicitly votes to do so. This issue has only intermittently arisen in a clean parliamentary fashion. Over the years, various senators may have quietly favored the old filibuster rule, but have not wanted to publicly take the blame for this position, preferring instead to shroud the issue in layer upon layer of procedural complexity. I know you're shocked by that. The Senate would ever do something like that. In 1975, a majority of the Senate in fact upheld a constitutional ruling of the vice president, sitting in the chair, that a mere majority could rightfully end debate on filibuster reform and overturn the old filibuster rule by simple majority. Shortly thereafter, however, the Senate voted to reconsider its earlier action, leaving us today with a Rorschach blot precedent whose meaning is largely in the eye of the beholder. In the early 21st century, Republican senators, frustrated by the success of the Democratic minority in blocking votes on various judicial nominations, loudly threatened to revise the old filibuster rule by a simple majority vote. This threatened revision, popularly nicknamed the nuclear option, never came to a conclusive floor vote. Instead, Democrats moderated their obstructionism and Republicans sheathed their sword. Precursors of this nuclear option, also known as the constitutional option, were forcefully advocated by prominent senators throughout the 20th century. And at various moments over the last 60 years, these precursors have in fact won the considered support of vice presidents and Senate majority leaders of both parties. Many of the most important filibuster reforms of the 20th century came about when reformers first threatened the constitutional option and then compromised by effectuating their desired reforms in an endgame process that formally obeyed the Senate's Catch-22 rule structure. If a Senate majority were truly powerless to set things right, then Senate practice would be wildly out of step with the practice of its sibling body, the House of Representatives. In the House, majority rule rules today and has always ruled. While this fact alone does not prove that majority rule is required by Article 1, Section 5, it surely confirms that majority rule is consistent with this section. The politically convenient assertion that today's Senate majority is simply a powerless captive of ghosts of Senate past should ring particularly hollow to British ears. And this hollowness deserves special attention in any analysis of how America's Constitution might look to a proper British constitutionalist attentive to unwritten constitutional norms and principles. While Britain has never had an American-style written constitution, the British have developed a deep understanding of the proper relationship among parliaments over time. It is a bedrock principle of British constitutionalism that one parliament cannot bind a later parliament. Otherwise, the inalienable right of parliamentary self-government would be lost. Indeed, what makes a right inalienable is precisely the fact that it's incapable of being waived, even by an actual practice of apparent waiver. Just as Americans at the founding surely understood that no person could be a judge in his own case. That's, by the way, a reference to Chapter 1. In Chapter 1, I basically asked the following question. Who would preside at Joe Biden's impeachment trial? Any vice president's impeachment trial? Because if you look at the text of the Constitution, it says the vice president. It's tried in the Senate, vice president, the presiding officer, and I try to show you that that can't be right. And we have to go beyond sometimes the written words to deeper underlying principles and premises. And in that, I show that one very deep principle and premise is that no person can be a judge in his own case. And I tell you about what Blackstone said about all that. And then I tell a really fun story about the actual impeachment trial of Andrew Johnson, where a very similar issue, in fact, came up in the opening minutes of the very first presidential impeachment trial we've ever had in American history. So check out the first 5 pages, and if they don't suck you in, I failed. Just as Americans of Chapter 1, there's a little preface that's a little more boring. But Act 1, Scene 1 is a really interesting episode in Washington, D.C., the opening moments of the very first presidential impeachment trial. Just as Americans at the founding surely understood that no person could be a judge in his own case, thanks in part to Blackstone's clear formulation of the basic principle, so too the founders were intimately familiar with and embraced what Blackstone had to say about the relationship between one legislature and its successor. Quote, acts of parliament derogatory from the power of subsequent parliaments bind not. Why not? End quote. Because, Blackstone explained, prior parliaments are not legally superior to subsequent parliaments. By what voting rule would each parliament proceed? Here too Blackstone was clear. Quote, in each house, the act of the majority binds the whole, unquote. So we got Thomas Jefferson, we got Ben Franklin, we got Bill Blackstone, we got John Locke, The same logic applies on this side of the Atlantic. Each house can make rules for itself, but neither house can entrench rules in a way that prevents a later house from governing itself. Only the Constitution can create entrenched rules of this sort. And on this issue, the rule that the Constitution is entrenched for each house is majority rule. Because this protocol is established by the Constitution itself, the protocol cannot be changed by either House or by statute. Just as the Congress may not properly enact an ordinary statute that changes the constitutional rules governing how future ordinary statutes are to be enacted, c.e.g. Chada, so too, neither House may properly enact a House rule that changes the constitutional rules governing how future House rules are to be enacted. Here is one way, then, of pulling together the basic argument. We're coming close to the end, guys. It's obvious that some specific voting rule must be used to operationalize the Article 1, Section 5 power and duty of each House to determine its own rules of proceeding. If majority rule is not the implicit rule, what is? Without some jump-starting rule, the first House and the first Senate in 1789 would have faced an insoluble infinite regress problem. By what initial voting rule would each House decide what voting rule to use in determining its rules of proceeding? By what pre-initial voting rule would that initial voting rule be decided? By what pre-initial voting rule would the pre-initial voting rule be decided, and so on without end? But no such infinite regress in fact occurred in the first Congress, because majority rule did in fact go without saying in each House in 1789, just as it had gone without saying in each ratifying convention in 1787-88. This first set of Article 1, Section 5 votes thus established the first key point of actual practice. Just as the first House and the first Senate each used majority rule to decide its procedures, every subsequent House and Senate may and must do the same, for nothing in the Constitution made the Congress of 1789 king over later Congresses. All Congresses are equal in this respect. In fact, and this is the second key point about actual practice, neither House has ever formally required a supermajority for amendment of its rules. Not even Senate Rules 22 has the audacity to openly assert it cannot be repealed by simple majority vote. Rather, Rule 27 says only that debate on its own repeal cannot be ended by simple majority vote. It purports to be a rule of debate, not a rule of decision. The question thus becomes, is this supermajoritarian aspect of Rule 22 a genuine rule of debate or a de facto rule of decision? If Rule 22 simply means that the rule itself should not be repealed without a fair opportunity to debate the repeal, then Rule 22 is fully valid. But insofar as Rule 22 in fact allows repeal opponents to stall interminably so as to prevent a majoritarian repeal vote from ever being held, then Rule 22 is to that precise extent operating as an unconstitutionally entrenching supermajority rule of decision rather than a proper rule of debate. It's the right and duty of each senator to adjudicate for herself whether Rule 22 has in fact come to operate as an improper rule of decision rather than as a proper rule of debate. And in adjudicating that question, the Senate, acting as a constitutional court of sorts, acts by majority rule, just as the Supreme Court itself does when adjudicating constitutional and other questions. QED. My coda. A simple question. Is the Senate a continuing body? It turns out the answer is not so simple, as illustrated by last month's activities on Capitol Hill. And getting the right answer matters crucially for sensible filibuster reform in the weeks and months ahead. For some purposes, the Senate is surely a continuing body. Whereas the incoming House of Representatives had to affirmatively vote for John Boehner as its Speaker last month, no similar drama unfolded in the Senate. Harry Reid continued as Majority Leader purely by inertia, with no fuss or fanfare. So too, because Senator Pat Leahy had become Senate President pro tem in the old Congress, he simply remained in place as the new Congress commenced. For other purposes, however, the Senate is not a continuing body. All the bills that passed the Senate before January 3rd went poof as the clock chimed midnight. Most obviously, the $60 billion Hurricane Sandy relief package passed by the Senate in late December turned to dust at the witching hour. Thus, a new relief bill had to be affirmatively repassed by the new Senate alongside the new House. So the correct answer to our simple yes or no question is yes and no. Though this seeming doublespeak may trouble some lay folk, there's nothing sinister afoot here. Law often works this way, as many of you doubtless learned in your 1L classes. For example, are corporations persons, my friend? Yes and no. Surely yes for some purposes. Government may not deprive a corporation of its property without due process of law. But for other purposes, corporations are properly not treated as persons. The axiom of one person, one vote applies only to flesh and blood. But what unifying principle explains when to treat the Senate as continuous and when to treat it as non-continuous? And what does this unifying principle mean for filibuster reform? Because our written Constitution is remarkably terse, certain overarching principles must be inferred from the document read as a whole. Principles such as separation of powers, federalism, rule of law, no person can be a judge in his own case. Legislative bicameralism is another implicit principle. When passing laws, the Senate must act in tight bicameral coordination with the House. The House is obviously not a continuing body. Every 2 years, its entire membership comes before the voters who are free to choose a completely new slate. Might not be a bad idea. But I digress. Legally, no House member holds over from one House to the next. Because each House begins anew biennially, all House legislative bills legally expire when that House expires and a new House arises to replace it. In the spirit of bicameral symmetry and coordination, the same rules about legislative bills sensibly apply to the Senate. All Senate bills die when one Congress ends and a new one begins. Such has been the practice since the founding. But on matters other than bicameral lawmaking, the Constitution generally allows each chamber to govern itself, and neither need mirror the other. The House must choose its leaders and its own internal rules of procedure at the outset of each new Congress because all its members have been freshly elected by the voters. By contrast, only a third of the Senate's membership comes before the voters in any given election, so this chamber can simply allow its internal procedures and its internal leadership to continue by inertia. Harry Reid need not be re-elected at the outset of this new Congress, and he wasn't. But of course, he can be ousted on any day if a Senate majority so decides. So too with the old Senate rules, which need not be formally adopted every other January, but can be changed at any time. Which brings us back one last time, this time with feeling, to the question of filibuster reform. The old Senate's rules permitting filibusters carry forward by inertia. Of course, they can be changed in January of odd-number years as a new Congress begins, but they can also be changed on any other day, just as the Senate leadership can be changed at any time. Changing rules or leaders within a session is not improperly changing the rules of the game in the middle of the game. Rather, the game itself, as defined by the Constitution's governing principles, allows procedural rules and new leaders at any moment. But there is at least one basic constitutional principle that, absent constitutional amendment, cannot be changed, ever. Majority rule. Lex Majoris Partis. The Constitution makes no sense without this rule as the implicit backdrop. Constitutional amendments require supermajorities precisely because ordinary statutes do not. Overruling the president's veto requires a 2/3 of each house precisely because passing an ordinary law requires something less, namely a simple majority. In 1789, the first Senate adopted its procedural rules by simple majority vote, and all later Senates may likewise amend these rules by simple majority. Notably, as mentioned, the existing Senate's filibuster rules do not themselves purport to require a supermajority vote to change them, but they do purport to require a supermajority vote to end debate on the question of filibuster reform. The simple solution to the issue of filibuster reform is thus for the Senate to take Rule 22 at its word and insist that this rule remain a mere rule of debate rather than a de facto rule of decision. In other words, the Senate must see to it that internal rules of debate and procedure stay within their proper constitutional bounds and do not unconstitutionally morph into entrenched supermajority voting rules. The Senate itself, today or on any day, may properly decide that filibuster reform opponents are actually preventing filibuster reform from ever coming to a vote. If so, reform opponents have improperly crossed a constitutional line. The filibuster rule is no longer operating as a constitutionally proper rule of genuine debate, but has instead become an unconstitutional supermajority rule of decision. In this situation, a simple majority of the Senate can rule that the Senate filibuster is operating unconstitutionally in violation of the underlying majority rule principle that constitutionally governs both the House and Senate. Thus, a simple majority of senators can rule any filibuster out of order as a violation of constitutional first principles. And to repeat, and here I close, a majority of senators can do this today or on any day, not just in January of odd-numbered years. On this precise issue, the Senate is indeed a continuing body. No day is any different from any other day. And unless the Constitution itself explicitly specifies otherwise, as it does for veto overrides, impeachment trials, and so on, the Senate always, every day, today and every day, operates by ultimate majority rule. Every Senate rule and procedure must be amendable by a determined Senate majority if that determined majority deems the old rule unsuitable. It's just that simple. Thank you very much, ladies and gentlemen. So I think we've left a little time. I'll let you moderate.
Okay. Good. Let's see if there's Come on, great.
David? Well, you talked about symbolic unwritten sources for constitutional law. It seems like you and Blackstone, but the opposing side seems like their biggest person would be Jimmy Stewart, and Mr. Smith goes to Washington. So, I mean, do you think, like, practically, what, if any, import should that have?
You will see the words Jefferson Smith in that book, in the last chapter. One of my favorite movies of all time. And Jimmy Stewart took the floor and tried to make a case for himself and wasn't trying to prevent ultimately a vote. He just wanted to get his side out before a vote was taken, you know. So now, you know, I'm a Yaley and he's a Princeton man, but I'm a Jimmy Stewart fan. You know, so and this is a book that does actually try to talk about American culture. I have a little, well, actually, let me tell you, I already told you, I briefly made mention to a couple of texts that I think are in America's symbolic Constitution. But if I just said to you, the Constitution is our unifying symbol. It's our Queen Elizabeth, our Taj Mahal, our Mona Lisa, our Marseillaise. But it's not the only thing that binds us as Americans, as sort of a canonical statement of the American creed. What other texts are like the Constitution, have special cultural significance such that if the written Constitution were unclear, these other texts might actually help define the basic, and these are texts, ideally, left and right, red and blue, that we'd all accept. So what would you nominate? Gettysburg Address, Declaration of Independence. Those are two of my six. Ten Commandments is way too secular for, you know, a society in which there are non-Christians. You know, my parents, my brothers, some people in this room. So, and that's precisely what makes it not actually. Roy Moore might think so, but not so much. By the way. Federalist Papers. By the way, Federalist Papers mention Providence, and the Gettysburg Address talks about the Creator and Creators, you know, and actually the Supreme Judge of the Universe, and they don't mean John Roberts, you know, and Lincoln has the words "under God" in the Gettysburg Address. This nation under God, although they were airbrushed out of one unfortunate ACS version of the. I promise I'm not making that up. So some of these iconic texts, you know, do mention a religion. Anything else? So we've got the Gettysburg Address and the Declaration of Independence and the Federalist Papers.
I Have a Dream speech.
I Have a Dream speech, which is, all God from start to finish, wall to wall. And someone mentioned Brown versus the Board of Education. Those are 5 of my 6. And the one other one, some of you probably wouldn't pick, it's the Northwest Ordinance, which is hugely important, actually, in the antebellum period and, when America is composed not just of states, but states and territories. So hugely important for Lincoln's generation. But we just proved, this could have exploded in my face, but we just proved that actually we're all Americans. And that there actually is a set, and I do this everywhere, north, south, east, west. I've never been to Duke before, my first time here, but they say the same thing in California. They say the same thing in Scranton, Pennsylvania. You can do a YouTube. If you just YouTube my name, you'll see I played this game at Pepperdine, and they came up with the same things. I played this game at Scranton, Pennsylvania. I played this game 15 times. And you could have said, also the Gettysburg Address or the second inaugural of Lincoln. I mean, it could have been all Lincoln all the time. You could have done, but there is a core. And yes, I think I mentioned Frank Capra and Jimmy Stewart, and actually I mentioned Kate Hepburn and Spencer Tracy. I have a kind of stylized dialogue in one chapter in America's Feminist Constitution between, in effect, a Kate Hepburn character and a Spencer Tracy character. He's Adam. I call her Eve. Actually, in the movie, she's Amanda. Yes. American culture is important, and I say, actually, Jimmy Stewart wasn't preventing any vote, and in American culture, actually, Sam Ervin from this state and other people actually did try to prevent a vote, and if it weren't for Watergate, you see his reputation would be very different, because in American culture, actually, the Civil Rights and the Voting Rights Act actually are iconic. I hope the fifth justice, whoever he will be, will recognize that. Because I got, I think, 4 already who recognize that, and I got to convince one of the he's left. But I hope they will recognize that. So Jimmy Stewart is not completely irrelevant at all to the project of this book.
Your argument actually raises an interesting question. As you know, Article 5 of the Constitution provides for the amendment process. But it says that with regard to depriving any state from its equal suffrage in the Senate, you need the consent of that state, which
Correct.
means that, in effect, you need 100% of the states
Correct.
to go along. Now, would you say that it'd be constitutional to propose an amendment to the Constitution which gets 2/3 of both houses of Congress and also goes through ratified by 3/4 of the state, which actually repeals Article 5 and then coming back with a new Article 5, or at least having it in 2 clauses, would that be all right? And it seems to accord, at least with your notions. And also, given the 17th Amendment, in which the state legislatures no longer appoint the senators, it makes some sense, actually, to go to that, particularly with the extreme imbalance in populations between, let's say, California and Wyoming.
Great question. So I actually, in the last chapter of the book, talk about America's unfinished Constitution, the amendments of the future, the Constitution that your generation will help to write. And in that chapter, I talk about amendments that should happen and maybe that will happen and give you some rules for thinking about that. And I actually talk about modifying the Senate. Here are my rules for the Constitution of the future. If we can think about stuff that happened 250 years ago, we should be thinking about 250 years from now. We can be founders of the future. We should be thinking about our posterity. This is our responsibility. There are rights in the Constitution, but there are also responsibilities, even though some of this is part of the unwritten Constitution. And here are my 3 principles. One, as a practical matter, any amendment's going to have to be supported by both parties. I think amendments need to add to liberty and equality rather than detract from it, because all the amendments thus far, except for prohibition, have actually done that. So I'm for a same-sex marriage amendment of one sort, but not of the other sort, because one is actually anti-liberty and equality, and one is pro-liberty and equality. And third, as a practical matter, any idea that you're going to put in the federal Constitution probably is going to need to have been road tested by the states first. So our entire Constitution Written constitution, states did it first. Bicameral, 3 branches of government, that's the basic state model. Bicameral legislature, most of the states had that, not Pennsylvania, not Georgia today, not Nebraska. Juries, judicial review, separate bills of rights, single-member districts, 2 parties, first past the post. On issue, governors who look a lot like presidents. On issue after issue after issue, the federal constitution tracks state constitutions in various ways. On amendments, states had a Bill of Rights. Some states got rid of slavery. States let women vote first. Some states let blacks go first. So on issue after issue after issue, states road test things first. Now, states don't have malapportioned senates, post-Reynolds versus Sims. And one person, one vote is actually a deep part of it. It's a fulfillment of an equality idea. So it's very possible. Now, how is that going to happen? I say there is a possibility of a 2-amendment, 2-step, an amendment to repeal the Article 5 proviso, and then an amendment reapportioning the Senate. I suggest that there's a different thing, too, because that rule, it only applies to any amendment that actually reapportions the Senate. But it doesn't apply to any amendment that takes power away from the existing Senate and gives it to a new body that has a different apportionment. If you're Yiddish, you can call this new body the Shmenet. Because I was trying to be a little bit, more straight, I called it the upper chamber. But we could have just an ordinary Article 5 amendment that Section 1 of which drains all power from the Senate except the power to sit as the impeachment court for assistant postmasters general, gives all the power pre-existingly given to the Senate to the new upper chamber, and upper chamber to be apportioned as follows, and actually suggest what an apportionment system might be. Every state has at least 1. No state has more than 8. That's going to actually generate a Senate of about the same size as the current one. Now the question is, because that's still, without the proviso, it's going to need to get 2/3 of the existing Senate, counting Wyoming equally with California. 3/4 of the existing states, counting Wyoming equal. Why would they ever do that? And I posit a senator from Wyoming, and his name is Jefferson Smith, as in Jimmy Stewart. Okay, and here's what I want to engage Jefferson Smith on. I want to say he would never do it right now. The real Jimmy Stewart would, but no other senator would, because he'd be pulling the rug out from under his own incumbency. And so why the heck would he do that? Why would Wyoming ever go for that? So I propose that we think about constitutional amendments that go into effect 50 years from now, 100 years from now, that sunrise. We think about sunset legislation, that sunrise. This is a John Rawlsian idea about try to think behind the veil of ignorance about the future, about how we can be framers for the future, of what would actually be fair terms of engagement for future generations. There is a dead hand problem of a constitution, but each generation can't fully define all the fair rules of democratic engagement for itself. You need some pre-existing rules like majority rule and all the rest, and that's where one generation can confer a huge benefit on later generations to set up fair rules of engagement for setting up the democratic game for later generations. So this is actually what they can't fully do for themselves and we can do for them, and I want Jefferson Smith and the people of Wyoming to ask themselves the following question. What would be fair for a set of rules, because it's not going to affect you personally. You're going to, these don't go into effect for 100 years, so you're set for now. But your great-grandchildren, if you're from Wyoming, more likely to be North Carolinians or Californians or New Yorkers than they are Wyomingians. If you think it's fair that Wyoming, because it's God's country, deserves more seats proportionally, well, then you think it's fair. And then on the Rawlsian conversation, you're not persuaded. But if you think it's not really fair, but it just suits your current interests right now, but that you want to be genuinely impartial among all your grandchildren behind a veil of ignorance, some of whom might be gay or straight or rich or poor or male or female, a Californian or Wyomingian. That's how I end the book. I want you actually to, I think, I end with this sort of an interesting story. Now, this is my Marco Rubio moment. I'm walking off camera, you see, and I'm coming back. I didn't quite maintain eye contact. I know we have to leave. So here's the last passage. Last paragraph. If it makes sense for modern American constitutionalists to attend to words written and deeds done centuries ago to form a more perfect union, it also makes sense for us to struggle to envision and help to birth a still more perfect union centuries hence. By the way, they did this with 1808. They just didn't do it enough on slavery. You know, these sunrise ideas, rules going into effect in the future. Much of American history remains to be written, and much of American constitutional law remains to be framed. Faithful constitutionalists labor under a twofold constitutional responsibility. We must look backward in time and claim our constitutional inheritance, and we must look forward in time and make our constitutional donation. Though this second responsibility does not reside on the clear surface of any explicit constitutional text, surely it forms an integral part of America's unwritten Constitution. Thank you.
Produced by Duke University. Online at duke.edu.